AG, the PNCR through Ms. Carol Smith-Joseph is challenging the verification process, how 𝐒𝐸𝐞 conducts that verification process with respect to voters' addresses. What's your government's position on this particular matter? And do you see it affecting the elections in any particular way?
So the legal issues that are raised in this case, in my respectful view, have already been canvassed before these courts, and I believe sufficiently settled by a ruling of the very judge before which this case is now fixed. That is Chief Justice George. You would recall when we were in the opposition, a case was filed in the name of Christopher Ram by yours truly. In that case, I made a number of submissions relating to a challenge against the scrapping of the then database and the implementation of a new house-to-house registration system. The database was going to be scrapped because it was felt that persons who are residing overseas or not in Guyana should not be on that database. And in the submissions which I made before the court, it was pointed out very clearly that the 1980 Constitution removed residency as a requirement for registration and voting. Residency used to be a requirement under the 1966 Constitution and the 1970 Constitution. In the 1980 Constitution, it was removed. So you could have been, or you can be living anywhere in the United States, in the United Kingdom, and you have a fixed address at any one of those locations outside of Guyana, but that fact doesn't disqualify you from voting at an election in Guyana, because the supreme law of our country that lists the qualifications for registration and voting, the Constitution doesn't make that requirement. So if you don't have to have a fixed place of abode or a fixed address in Guyana, but you can have in fact you can have a fixed address in Queens, New York, or you can have a fixed address in London, and you are still qualified to vote in Guyana by virtue of the Constitution, on what basis is there a requirement that you must live at a particular address in order to vote? Just work it out logically in your mind. And those were the very type of submissions which I made before Chief Justice George, as she still is Chief Justice, in that case 5 or 6 years ago. And those submissions were upheld. And the judge rendered a written judgment that spans several pages. And in that judgment, the judge recited all the law, the historical evolution of these requirements, that they are part of the Constitution, and therefore to remove a person from a list or to prevent the registration of a person because that person is not living at a particular fixed place of abode would be unconstitutional. And every law that is passed must be consistent with the Constitution, or that law will be inconsistent or would be unconstitutional to the extent of that inconsistency. You would recall, and if you check the record, you can bear me out, the then Attorney General Bassey Williams appeared in that case. 𝐸𝐫𝐞, which was then headed by retired Justice James Patterson, brought in a senior counsel from Trinidad and Tobago. We heard a matter in that court at the end of this wing of the building. We had days and days of arguments. That decision of the learned Chief Justice was never appealed, either by Basil Williams or 𝐸𝐫𝐞, because I felt, and I'm sure that they felt, that it accurately captured the law. So anytime any person is refused registration or would be refused the right to vote because of some deficiency in their address, that would be an abrogation and a violation of not only the Constitution, but that person's constitutional right to vote. And that is what this case is about. It's re-arguing that position all over again. That is why today there is an application to expand the case, expand the fixed date application filed by Carol Joseph. And when you look at what they are expanding, they are simply adding more factual examples to the legal issues. And I didn't object to that, because the legal issues remain very narrow. Whether there is a requirement for a person to live at a particular place in order either to be registered or to vote. And the position has already been settled and clarified by our courts, reviewing the relevant constitutional and legal provisions. And I believe that decision of the court is quite settled. Even the opposition accepts. Even the PNC, APNU, and AFC, they have accepted that that is a legal position. I don't know why they're filing this case, but I believe they have a right to do so, and we will have to go through this whole ordeal of these arguments. These arguments are not new. They have occupied the newspaper columns for years now, since the ruling of the learned Chief Justice. And I believe everyone have accepted the learned Chief Justice's ruling as an exposition of the law, and they have never appealed it. And we have not changed the law in that regard. What we did was to make amendments to the National Registration Act to bring it in line with the Constitution. You see, in 1980, when the Constitution was changed, you had some inconsistent parts of the National Registration Act still left on the record because the corresponding changes were not made. Remember, the National Registration Act is an old act. It was drafted when the previous constitutions were in force. So if you adjust that constitution now, you're supposed to adjust the law to ensure that the law is in sync with the Constitution. That was never done. We have done that now. And that apparently has raised eyebrows. But we will see how the judge will rule. It's the very judge, I'm happy that the very judge that interrogated these issues and wrote elaborately on them is the very judge before whom we are appearing.
Thank you so much, Attorney General.
You're welcome.